We know now for sure that what Peter Herman put on his schedules was the truth. Almost the entire bankruptcy order, which is what the bar hitched its wagon to from the very beginning, was based on Schedule B. Mr. Herman was not a lawyer in those proceedings representing a client. That's been noted. What matters is the February 18th date when the petition is filed.
No, I understand that.
At the time the petition was filed, he had received nothing and the law firm had received nothing, and there was still ongoing litigation as to whether the law firm was going to get any or all or part of that money.
Right.
Advice of counsel is not a defense in a bar case. Period. End of discussion, and it never was discussed again. The context of this is Peter Herman had taken on two massive cases, one of them very late in time, and one on behalf of two clients, two of his character witnesses. The clients made millions and millions of dollars. Mr. Herman was not going to make millions and millions of dollars, but he got a verdict in two cases, and then with their appeals, and then the publications that talked about what a great job Peter did. It was David versus Goliath. It was well known, well publicized. If something is a lie, it has to be in your mind. If you are crazy and you think it's the truth, is it a lie? No, it's not right, but it's not a lie. Both Peter and his lawyer testified that what happened was his lawyer said, give me all your documents, give me all your records, and we, as our courtesy in these types of cases, we fill out the paperwork. In the paperwork was his prior history, his tax returns, everything. The lawyer filled it out, and then the lawyer said, Peter, tell me, and this is his testimony, tell me, ballpark, what you normally get as a bonus if you get a bonus. It was never challenged, and there was not a single fact witness other than a trustee who was called by the bar. The trustee said, upon reviewing the schedules, he doesn't really pay much attention to I. It's sort of a throwaway. But had he looked at it, it would have put him on notice that Peter was getting a bonus, which would have been one of the discussions he had with the firm. Standard operating procedure, which of course Mr. Houston, the lawyer for Peter, knew and told Peter that this is what's going to happen in this proceeding. Peter would have to be either insane or a moron to think that no one was going to know about these $25 million in $50 million in judgments from which his firm was going to get about $10 million. In this case, it's without hyperbole that I say that Mr. Herman's discipline case is factually rare, if not unique. Bankruptcy law is a hyper-technical, almost obscure practice area. Very simply, he was the unwitting client relying upon the advice of his lawyer. If he's not guilty of that contempt for that reason, he's not guilty of a law violation.